So, we're going through the divorce process. You've filed your complaint. We've gotten the discovery done. We've gotten Pin-to-Light support set. How are we going to get this resolved? You don't want to go to trial. Trials, lawyers love to go to trial. It's what we're trained for. It's what we're good at. It's a destructive process for our clients. So we want our clients to resolve their cases other than that. First thing to do, discuss settlement. Talk to your spouse if you can talk to your spouse. The lawyers can exchange offers back and forth. We think that's a great idea. But if that doesn't work, there's a thing called alternate dispute resolution. And the shorthand for lawyers is ADR. You'll hear it over and over again. And the most prevalent form of ADR is mediation. And that's when the lawyers and the clients, and sometimes in rare cases, it's appropriate for just the clients, to sit at a table with a third person, usually but not always a lawyer, to talk about, well, these are the issues. These are potential solutions to those. Well, how can we work these issues out? Well, if your position is this on this, what about your position on this and this? If you could give on this, could you give on that? And mediation, we find, helps us resolve a very large number of cases so that the people don't have to go to trial. Now, mediation is a surprisingly exhausting process. People don't feel the tiredness when they're there, but at the end of the day, it really gets to them. Now, we do mediation differently than many other law firms. We prepare for mediation as sincerely as if we were preparing for trial, as intently as if we were preparing for trial. We have mediation notebooks where we show up with, among other things, the marital dissolution agreement, and if need be, a parenting plan already typed up. For notebooks, we give everybody, and that's the first step. The next thing we do is we have a laptop, and the laptop has the marital dissolution agreement and the permanent parenting plan. And we negotiate with the other side on the documents so that everybody knows where everybody is. And we then have a little portable printer. It's a cute little printer, about that big. And the great thing about it, it can print up to 19 pages a minute. And then when it's all over, we know what the deal is, and everybody signs it. A couple of years ago, some people came to me. They had gone to mediation, both of them represented by other lawyers, nobody in our office. They went to a mediator I know, and everybody left happy. Why'd they both leave happy? Because they divided the house, the proceeds from the sale of the house, 60-40. So you know it was a couple of years ago because there was actually proceeds from the sale of the house. And they divided it 60-40, and everything was great. They went home, they went to bed, woke up the next morning, and they were talking about, well, you know, I'm glad we got everything worked out. This is not going to be a big problem. And, you know, thank you for giving me 60% of the house. What? No, you gave me 60% of the house. No, you got 40%. I got 60%. Well, they both had left mediation thinking they were going to get 60% of the proceeds of the house because nobody got it in writing. And they ended up, one of the spouses ended up hiring me. And yes, guess what? We divided the house in the end 50-50. The people spent almost $20,000 getting that done. That's why when we use this little printer and print it out, and everybody looks at it and goes, well, wait a minute, I'm not getting 60%. All right, then we settle that there, and everybody leaves and it's settled. It also relieves us of problems with buyer's remorse, people waking up the next morning going, oh no, I didn't get the deal I should have got, let me get out. Well, you probably did. So that's what we do. We also have a little scanner we bring along, and we scan information and documents and checklists and mediation positions in as we go along. We actually take a real little office when we get there. But what we found is with the preparation and with the documents to prevent fall aparts, we're able to successfully mediate a higher percentage of cases. Because mediation's a really good thing. Now, there are other alternatives. Judicial settlement conference. Judicial settlement conference, ooh, that sounds scary, but basically it's mediation with a lawyer doing it, with a judge doing it instead of a lawyer, okay? So even I can make mistakes. So judicial settlement conference, mediation with a judge. Arbitration, arbitration is, think of it as binding mediation. Now, mediation, y'all work towards a settlement, but nobody has to take it. In arbitration, though, you have a hearing based on whatever rules you agree to use, and in the end, whoever is conducting the hearing gives you a ruling. It's like having a private judge. Okay? Those are the most common forms of ADR. They're useful, they're important, and we recommend them, and we believe lawyers that are properly prepared for them can get the best results out of them. You'll also see there's another concept these days called collaborative law. That's where everybody works from the beginning, they waive confidentiality, and they work together. In the proper case, that's useful. But if one of the sides decide to spike the process, then everybody's lawyers are thrown off the case, and they have to get a whole new set of lawyers. So collaborative law, mediation, arbitration, judicial settlement conference, all these are tools. And my job as your lawyer is to find the right tools to get you from where you are in the process out of it and it over. Thank you very much. If you'd like some more information about divorce, you can go to our website, aboutdivorce.com. Thank you.